out with the old and in with the new. What are the logistics associated with this forms revision, all of these forms updates? All of the new forms and the revised forms will be released for your use on March 3rd. You have copies of all of the forms, the revised forms and the new forms in your materials packet that was provided to you as part of this class. You'll notice that every single one of those forms has a big sample watermark across the face of it. That is because it is imperative that nobody use the forms as transactional documents until March 3rd, 2021. And the reason for this is because the whole point of our statewide form system is that we have an enormous amount of predictability for all of you. When you receive a statewide form, purchase and sale agreement from another broker, you know what the boilerplate language says. If everybody was using different forms, it would be a guessing game for each of you as to what form you were looking at when you got an offer or counter offer, and that would be no good. So March 3rd is the date that these forms will be released to you through your forms provider, and that would be the first date that you should start using them as transactional documents. So what if you receive an offer on March 2nd and you're representing the seller who wants to counter offer on March 3rd? Do you need to rewrite the entire offer so that the whole offer is on either post March 3rd documents or pre-March 3rd documents? And the answer is no. You can mix the forms from the buyer's offer to the seller's counter offer. What if the buyer wrote an offer that included, for example, a Form 35 inspection contingency, but your seller and your seller is going to counter? Does that mean that you should pull out the buyer's pre-2021 inspection addendum, the Form 35, and replace it with a new Form 35? It does not mean that at all. It means that if you want to do that, if your seller prefers the terms of the new Form 35 versus the old Form 35, then in the form of a counteroffer, you could certainly switch those two forms, and that would constitute a counteroffer, even if you made no other changes in the agreement. But you're not obligated to do that. Let's see, I think I might have already answered this question, but the last bullet point, is it okay to combine the revised forms with the old forms going forward in ongoing negotiations? Absolutely. You can have pre-2021 forms mixed with new 2021 forms. We have one form system change, a change that is reflected in every form in the statewide form system. And that is a wholesale replacement of the term selling broker and selling firm with the terms buyer broker and buyer brokerage firm. Where this is going to become the most significant is when a broker is involved in a transaction as the seller's agent, but writing the offer for the buyer. And this was the focus of a significant discussion among the members of the statewide forms task force, because the change from selling broker to buyer broker and selling firm to buyer brokerage firm is a way intended to keep up with the market, with the industry itself. We've evolved from an industry, where really prior to the agency law, every broker represented the seller. And that was where we adopted this term of listing firm and selling firm, or listing broker and selling broker, because all brokers represented the seller way back when. But of course, we now have the agency law. We have separate agency for sellers and for buyers. And the natural evolution of that is that we would shed the term selling broker because it has become confusing to industry members and consumers alike. So the more representative term is the term buyer broker. Why is that a tough term at all? The only reason that we could conceive of on the statewide forms task force that it could be a challenging term is in a scenario where, let's say you're the listing broker and you're holding your own listing open, and a buyer walks through and says, I love the house, I want to buy it. Not working with another broker, I don't have my own agent, I want you to write my offer. And you at that point can say to the buyer one of two things: I'll either represent you as a dual agent and then you take care of that, or I won't represent you as a dual agent. I'm happy to write the offer for you, but I won't represent you as a dual agent, which means that if we go forward, buyer, you will be unrepresented. Now, we're going to cover in more detail this discussion when we get to the agency disclosure provisions. What I want you to know for right now is if the buyer were to instruct you in that case, yeah, I want you to go forward. I want you to write the offer for me, even though you represent the seller exclusively. When you get to the bottom of Form 21, below the signatures, and you identify buyer broker and listing broker, you would not put anything in the category under buyer's signature under the heading buyer broker or buyer brokerage firm. Why not? Because you're not the buyer broker. You're not representing the buyer. Instead, you are representing the seller exclusively. There would only be one broker and one firm involved in that transaction. So the escrow company would have all of the contact information they needed by having your contact information under the seller's name. So you would leave the buyer broker's name, that column, blank in that instance if you were representing the seller exclusively and writing the offer for the buyer. The listing agreements, Forms 1A and 1B, have been revised. The first revision is a boilerplate, well, they're both boilerplate revisions in this case. The first one is to paragraph 1, and it's a one-sentence change that allows, or that it creates consent by the seller to the listing firm receiving compensation from more than one party. It's kind of it's not something that most sellers are probably going to pay a lot of attention to. It's an important consent if the listing broker is receiving compensation from more than one party. And this is, again, keeping up with the evolution of the industry. We are seeing that in this kind of crazy seller's market, where sometimes a listing broker will receive compensation from more than one party. The forms are also updated to include a fair housing reminder. And the language that is within the quotation marks of the second bullet point, that is exactly the language that has been added to the listing agreements. This language represents all of the protected classes in the Fair Housing Act from the state and the Federal Fair Housing Act, as well as the State Fair Housing Act. Your local jurisdiction could have additional protected classes. This boilerplate language does not include the fair housing classes of any local jurisdiction. This is state and federal law. Why did we put this in the listing agreement? Is it actually a term of the listing agreement? In some respects it is, because the seller is required, of course, to comply with the Fair Housing Act. Whether it's in the listing agreement or not, of course, the seller is required to comply with the Fair Housing Act. This would be your first opportunity in presenting the listing agreement to remind the seller of their obligations under the Fair Housing Act. If you learn any resistance at that point, that would be your first indication that you need to have your radar up on this issue with the seller. Perhaps more importantly, however, because I don't believe that most sellers are going to intentionally violate the Fair Housing Act, although many sellers may find themselves in a position where they are potentially violating the Fair Housing Act, even without intending to do so. This language in the listing agreement provides you an easy reference tool to be able to take your seller back to a contract they've already signed, remind them of the classes that are protected under the Fair Housing Act, remind them why they cannot engage in the action that they are intending or that they have indicated they're intending, and help them understand why it is they need to move forward in a different direction, a direction that you do not believe has the potential for violating the Fair Housing Act. Liz, are there any questions?
There's one question. Would I still receive the buyer broker commission if the buyer broker info lines were left blank?
Yeah, so this question goes back to what we talked about a minute ago with regard to how you're going to fill in the buyer broker blanks below the buyer's signature. Remember that the only reason that you're getting a commission in any event, the only reason compensation is paid is because seller has signed a listing agreement. I'm sorry, there could be exceptions to this rule, but in most cases, the only reason a commission is being paid is because the seller has signed a listing agreement with the listing firm. And in that listing agreement, the seller agrees to pay X, let's assume it's a percentage, X percent of the sale price to the listing firm. So the seller's going to pay the full X amount to the listing firm. The listing agreement then goes on, consistent with the MLS cooperation agreement between cooperating firms, to say that if a selling office brings a ready, willing, and able buyer, then the listing office will share compensation from the commission paid by the seller with the cooperating office. But if there is no cooperating office, seller has still committed to pay X percentage of the purchase price to the listing firm. So yes, the full commission is owing and payable from the seller, whether there's a selling office involved or not.
Okay, there's one other question.
Purchase agreement. Okay, go ahead.
Who would the listing firm be receiving compensation from as reflected in the change?
This is not impacted by the change at all. The listing firm is going to receive compensation from the seller who signed the listing agreement. Okay, the purchase agreements. There's 5 purchase agreements available through the statewide form system. Vacant land, improved residential real property, condo, et cetera, et cetera. We are talking today only about Form 21, but you should know that the changes that we're talking about today have been consistently applied through every purchase and sale agreement in the statewide form system, to the extent that the change we're discussing applies to that particular purchase and sale agreement. The top 4 bullet points are fairly in-depth discussions, and each bullet point has its own PowerPoint slide. The bottom 2 are pretty simple, and so we're going to cover those 2 just on this PowerPoint slide right here. The first is a revision to the included items provision, and I'm not talking about paragraph 5. I'm talking about the boilerplate included items provision, paragraph C. It's on the 2nd page of Form 21. In that boilerplate provision, the words garbage disposal have been included, have been added. Most of us would probably think of the garbage disposal as being a fixture in any event that seller would leave with a property. But apparently there have been some sellers who, after they purchased the property, added a garbage disposal, and so they assumed they would take the garbage disposal with them when they left. So this boilerplate language clarifies that if there's a garbage disposal installed in the home, it's going to stay with the home at closing. The other boilerplate provision in the Form 21 that's really below the radar, if you will, is found in the very last paragraph of Form 21, paragraph X, which is just a gigantic CYA provision. It is a provision that protects brokers and sellers by advising buyer of all of the many topics that buyers should consider investigating and researching relative to the property before they purchase. Boilerplate language has been included to reference soil or other contamination. So when buyer is doing their research of the property, paragraph X will remind them that if they are concerned about the potential contamination or the quality of the soil, they should do their own investigation as to what might be in the soil located on this property. Similarly, wherever the word defective is located in that paragraph, we've added the word or hazardous. So it's now buyers advised to research on their own defective or hazardous conditions on site. The earnest money provision is very substantially revised to correct a number of issues that have become difficulties within the industry because of changes, really primarily technological changes. The earnest money provision that you're familiar with today, which is primarily housed in paragraph B of Form 21, that's on the 2nd page of Form 21. The provision as it exists today says that buyer's earnest money is due not later than 2 days following mutual acceptance, and that buyer's broker has 3 days to deliver buyer's earnest money either to the firm's trust account if the firm is holding it, or to an escrow company if the escrow company is holding it. And buyer broker's 3 days run from either the date that buyer broker receives the money, or the date of mutual acceptance, whichever comes later. But it's kind of this two-part system where buyer delivers, and then buyer broker has this obligation to deliver if buyer broker is who receives the money from buyer. It's possible. So let me back up. So in the 90s, the earnest money agreement, the earnest money provision as it exists today, with one modification I'll tell you about in a minute, was drafted. And it was way back in the 90s when the Department of Licensing came to the industry lawyers and said, we've got an enormous problem because we have a countless number of sellers who complained to the Department of Licensing that when they went to recover the earnest money to which they are entitled because of a buyer breach, lo and behold, the earnest money is not there. And now they can't get it, and they are hopping mad. And so they're complaining to the Department of Licensing. This has become a big issue, industry, and if you guys don't fix it, we will fix it through regulation. So the industry said, whoa, thanks for the heads up, we'll fix it, and created the paragraph B largely as it exists today. But back in the 90s, what paragraph B said was that buyer must deliver the earnest money to buyer broker, who then had responsibility for getting it delivered within 3 days. And that step of forcing the delivery to buyer made the buyer broker accountable for whether or not the earnest money was actually delivered timely, because it had to arrive in their hands. And if it didn't arrive, then they knew it wasn't timely. And so it allowed the Department of Licensing to put a big burden on buyer brokers to disclose if the earnest money was not delivered timely by the buyer. Fast forward to, I don't know, it's probably been 5, 6, 7 years ago at this point. I can't remember exactly when the form was modified. But as it became a more and more frequent occurrence for buyers to simply wire funds directly to an escrow company, then the form was revised to allow the buyers to do that directly to escrow. But even so, the buyer's earnest money was still due by boilerplate not more than 2 days following mutual acceptance, whether it went directly to escrow or whether it was delivered to the buyer's broker. And then if it went to buyer's broker still had those 3 days. That 3 day mechanism is completely gone with the form's revision. It's gone. There's only one blank now associated with buyer's delivery of earnest money. And I'd appreciate it if you go ahead and look at the form. So all the forms were delivered to you. Hopefully you have them available to you. Form 21 is the second form in your forms packet behind the listing agreements. Take a look at the first page of Form 21, paragraph 7, which is the earnest money paragraph, and the line directly below the words earnest money says delivery date blank. On that date, on that blank line, you are expected to write a number of days. The number of days that you write on that blank, once the parties agree, is the number of days after mutual acceptance that buyer's earnest money will be due wherever it's going. So the form also identifies who's holding the earnest money. Let's assume it's going to be held at escrow. And let's assume that you wrote 5 in that blank. That would mean that 5 days following mutual acceptance, buyer's earnest money must be at the escrow company. If buyer intends to mail the check using the United States Postal Service, I'm going to put my check in an envelope and address it and stamp it and drop it in the big blue box. That's fine if buyer wants to do that, but the check has to arrive at the escrow company not later than the day on which it's due. This form's revision eliminates the mailbox rule. If you were familiar with the mailbox rule prior to today, it's gone in this contract. It's not gone as a doctrine and law, but it is gone from the statewide forms purchase and sale agreement protocols. Your buyer also needs to be aware, though, that if they're going to go back home, maybe they came from out of state, they're going to get back home, they've got to transfer some funds from the stock market, get them into their bank account so they can wire the funds. Make sure buyer understands that the funds have to be there on that day. Many banks, every bank, has a wire cutoff. And if your buyer doesn't meet the wire cutoff for that day, the wire funds aren't going to get there that day. So if your buyer's funds are due on Wednesday and they show up at the bank on Wednesday at 3:30 after they get off work, their funds are going to be late even if they wire them. So make sure buyer understands that. The form is enormously simplified because of this change. But there are still some background issues with which you're familiar that you have to work with. For example, if the buyer delivers buyer's earnest money to you as the buyer's broker, which is entirely possible, there's nothing that prevents or even dissuades a buyer from doing that. Buyer could deliver an earnest money check to you as their buyer broker. And if they do that, you will have to give the buyer a receipt for that earnest money. You can use Form 89 or any other receipt that you'd like to use. But you must give a receipt to the buyer if you touch the buyer's earnest money. If you never touch the buyer's earnest money, then you won't give the buyer a receipt for the earnest money. If you do touch the earnest money and give a receipt to the buyer for the earnest money, you must give a copy of the receipt to your firm for retention in the firm's transaction folder, and you must deliver a copy of that receipt to the broker on the other side of the transaction. That's an old rule from today's form, and it applies to the new form if you touch buyer's earnest money. But understand that under the new form, there's absolutely no reason that you need to touch the buyer's earnest money unless that's just the easiest way for the buyer to timely deliver the earnest money to wherever it's going. Promissory notes. If we were in class, I would ask, and does anybody still use promissory notes? And I would ask that question fully intending to shame you if you said that you did. And I would do it with a smile on my face, but then I would ask you why you're still using a promissory note. And invariably, there would be 4 or 5 of you who would raise your hand saying that you do. And I would go around the class and I would call on each of you. And you would invariably tell me some reason that when you drill down to the nugget of it, it would be because we're trying to delay the date on which buyer's earnest money is due. And you might say it's because they've got to have time to get funds out of the stock market, or might be because they want to deposit it after they've done their inspection, or whatever it is that you want to tell me. It would always be controlling the time driven. So I want you to think about the operation of this form as it's revised. The way the form is revised, the buyer has 100% control over when the buyer's earnest money will be due based on how the buyer fills in that blank. One buyer's earnest money might be due 2 days after mutual acceptance. Another buyer's earnest money might be due 15 days after mutual acceptance, all depending on how that blank gets filled in. Now, certainly the seller can counter, and that could potentially become a negotiated term. But understand, there's nothing that dictates buyer's delivery of the earnest money within 2 days following mutual acceptance. However, if the parties fail to put any number in that blank, there is boilerplate language in paragraph B that says that by default, buyer's earnest money is due 2 days after mutual acceptance. It is a backup only. It is intended that the parties negotiate when the buyer's earnest money will be due. And of course, that negotiation begins with buyer's offer. Liz, are there questions on earnest money?
Yes. Is it delivery to escrow or deposit of earnest money?
Buyer's earnest money, if the escrow company is holding it, buyer must have the earnest money at the escrow company by the date that it's due. It's up to the escrow company to get it deposited within the regulations that apply to them. So if they can wait until the next day to get it deposited, that's their wheelhouse. We won't worry about that. All the buyer can do is get the earnest money timely delivered to escrow.
Okay. Would it be a breach of the RPSA if a check is selected for the earnest money, but then a wire is chosen by the buyers after acceptance of the offer? And the reason I'm
No,
go
go
ahead.
ahead. I'm sorry. No,
Uh,
go ahead.
okay. The reason he's asking because if the wire has issues, which occasionally happens, could they bring a check and other such change of delivery circumstances?
So in every contract, there is a substantive question of, I'm not saying this right. Every contract presents multiple opportunities for breach. And in fact, many contracts are breached by both parties. The question in every breach is, was it a material breach or not? Because if it's an immaterial breach, it's effectively of no consequence. If buyer were to say, I'm going to write a check, and then they wired funds instead, I suppose that would be a technical breach, but it would be immaterial and it would be of no consequence so long as buyer's earnest money was timely deposited with the escrow company. Nobody is going to be able to complain if buyer's earnest money is timely deposited, timely delivered by some means. Now, there could be, I guess, a substantive difference between wiring and delivering a check on the date that it's due. That would potentially be a substantive difference because then the check funds have to clear before escrow can account for the funds being in their account. But if it's going the opposite direction, where buyer said, I'm going to deliver by a check, but instead they wire funds, that would probably, I'm certain that would never be a problem. Liz?
Okay, that's all the questions.
All right. Agency disclosure. Okay, so here we are back to our open house. Actually, let's talk about the agency disclosure provision first. I'm sorry. What you see between the quotation marks is exactly what the agency disclosure provision now looks like on the revised Form 21. It is a simplified provision. So when you're filling out the form, probably as the buyer's agent, because typically it's the buyer's agent who completes the agency disclosure provision as part of the buyer's original offer, you're going to write that buyer is represented by, if you're representing the buyer exclusively, you would write buyer broker. Buyer broker means buyer broker exclusively, because the only other choice is by the buyer/listing broker, which would be a dual agent. If you're representing the buyer and you're not a dual agent, then the only choice is buyer broker. And if nobody is representing the buyer, if buyer has no representation in this agreement, in other words, you're filling out the form as seller's exclusive agent and buyer has no representation, then you would check the box unrepresented. And then when you get down to the seller's represented by, if it's true that the seller is represented by the listing broker exclusively, you would mark that box. If you are a dual agent, then you would mark this box. And if by some circumstance the seller is unrepresented, then of course you would mark this box. So let's take ourselves back to the open house where the listing broker is holding their own listing open. And a buyer wanders in and says, I want to write the offer. I don't have my own broker. I'm not represented by an agent. I want you to write the offer. And you say, great. You may already know in your own mind whether or not you are willing to be a dual agent. And if you're not, then you're going to skip the first part of this next conversation. But if you're willing to be a dual agent, then the next thing you would probably ask the buyer is, so buyer, I represent the seller, and as it stands, I represent the seller exclusively. Would you like me to write the offer as a dual agent, which means that I would represent you and the seller? I would then be essentially a conveyor of information. I would not be able to advocate on behalf of either of you, but because I would be what the law defines as a dual agent. Here's a copy of the law of agency, a pamphlet that describes these various agency relationships. Buyer, what would you like? And if the buyer says, yes, I want you to represent me, then before you pull out any purchase agreement forms, you pull out what? A buyer agency agreement, because you cannot be a dual agent unless you have both a written listing agreement and a written buyer's agency agreement. And without both agency agreements in writing, signed by the consumer to be bound thereby, you are not a dual agent. If all you have is a written listing agreement and no written buyer's agency agreement, then you are seller's agent exclusively. So you need to mark the box that corresponds with who you actually represent. And if you're the dual agent, if you have a written agency agreement from both buyer and seller, then you would mark this box for both seller and buyer. But if you're holding that open house and the buyer walks in and wants to buy it, and you don't do dual agency, or you ask buyer the question, do you want me to represent you? And buyer says, no, I'm good. I don't need representation. I'm happy to just go as it is. You go ahead and represent the seller. I'll take care of myself. Okay. In either of those situations, you are now the seller's exclusive agent. So seller represented by listing broker, buyer represented by unrepresented. And this is when you get down to the signature lines, and below, the left column is buyer's signature line and where you identify buyer's broker. And if there is no buyer's broker, you're going to leave that identification provision blank. All of your identification information will be under seller's signature and under the heading for listing broker and listing firm. Questions, Liz?
Yes. Doesn't one need seller's permission first before writing a P&S changing your already agreed upon seller representation?
Absolutely. And that consent is housed in the listing agreement. Boilerplate listing agreements include consent by seller to broker serving as a dual agent if the broker who sells the property also represents the buyer by written agency agreement, and in a scenario where the listing broker's managing broker would be a dual agent if another broker also under the management authority of that managing broker represents the buyer. So yes, we do need seller's consent, and it has already been obtained in the listing agreement. Anything else?
That's it.
Okay. FIRPTA, the Foreign Investment in Real Property Tax Act. This is a provision. It is paragraph 14 on the face of Form 21. It is treated as not only a flyover provision by many sellers and listing brokers, but as an utter nuisance to them. It's offensive to have to disclose my citizenship status. I don't intend to disclose my citizenship status. If you can't tell by looking at me that I'm a U.S. citizen, then I'm not going to give you any more information than that. Okay, great. Not great. Why is that a problem? Because the IRS makes it a problem, and it makes it buyer's problem. And if buyer has a problem, it will become buyer broker's problem. Here's how that whole thing plays out. The IRS code says that if seller is a non-resident alien and the transaction fits certain parameters, then a certain amount of seller's proceeds must be withheld by the closing agent at the time of closing. And if that doesn't occur, then sometime after closing, an IRS agent is going to come knocking on buyer's door, not buyer broker's door, buyer's door, saying, here you are served with whatever the documentation is that says you owe the U.S. government a whole bunch of money in the form of seller's FIRPTA taxes that were not collected at the closing of the transaction. Now, when buyer gets a tax bill from the IRS for, let's say, tens of thousands of dollars, you think they're just going to say, oh, gosh darn it, another problem overlooked. I guess I'll just pull out my checkbook and write a check. I don't think so. I think buyer's going to pick up the phone and call who? They're going to call you, the buyer's broker, and say, hello, how did I get here? I relied upon you. You were my agent. You were taking care of me. And we have too many sellers who are refusing to sign and upload the 22E FIRPTA certificate so that buyers and buyer brokers can avoid ever finding themselves in that situation. What does it look like? It looks like this. In a perfect world, and this isn't even all, you don't have to work very hard to imagine this perfection. Every listing broker should be doing this. In a perfect world, the listing broker delivers the 22E, the FIRPTA certificate. A copy of it's in your materials. It's not new. It's not been revised, but it's there for your reference. That the listing broker delivers to the seller the blank 22E at the same time that the listing agreement is delivered. The seller fills it out and signs it. Remember, when the seller fills out the Form 22E, they do not provide their social security number. The Form 22E says right on its face that seller will provide the Social Security number to the escrow agent. Seller fills out the form, signs it, listing broker uploads it as an attached document to the MLS printout. Buyer broker comes along, prints that certificate out, uses the information from that certificate to mark the appropriate box on line 14 of Form 21, and then retains a copy of seller's certificate in the buyer broker's firm transaction folder going forward in time. Why is that important? Because the buyer broker, two things. The buyer broker needs to be able to rely on seller's signature on the certificate for how the form is filled out. And at an even more fundamental and basic level, there's no way that buyer broker can competently complete Form 21 without the seller's FERPTA certificate. There is no way that buyer broker can make a reasonable guess at how to fill it out. If buyer broker simply leaves it blank, maybe seller does, maybe seller doesn't, mark it themselves, complete the box. All of a sudden we have mutual acceptance. All of a sudden we're at closing. The box has never been marked. Escrow has no idea what seller citizenship status is. So buyer broker says, okay, then I'm just going to mark the box that says that seller is a resident, is a non-resident alien. Well, you can't do that because then you run the risk in a seller's market, particularly, of offending the seller and not getting a deal put together. So instead, you mark the box that says seller is not a non-resident alien. And seller says, oh, I kind of like that representation. Who says I have to change that? I'm not going to change it. Goes to escrow, doesn't get fixed. Seller is a non-resident alien. Escrow doesn't withhold funds. There is no good way for a buyer broker to mark paragraph 14 if listing broker hasn't done their job. And so we've had scenarios recently where sellers haven't uploaded or listing brokers haven't uploaded the FERPTA certificate. Buyer and seller get into a purchase and sale agreement. Buyer broker presses and asks for the 22E. Seller and listing broker ignore them, or worse, just defy that request and don't provide it. And now buyer's got a real problem. They're in a binding purchase and sale agreement, and seller is not being held to account for whatever FERPTA requirement seller may have. So the boilerplate language of Form 21 has been revised to accommodate that scenario. Boilerplate language, this is below the radar. It's not on the face of Form 21, but it's in the boilerplate language that pertains to paragraph 14 of Form 21 on the front page. And it says that 10 days following mutual acceptance, if by that time seller has not delivered a Form 22E completed and signed to the closing agent, copy should be delivered to buyer's broker, then after 10 days following mutual acceptance, buyer may deliver to seller a Form 90 FERPTA, a copy of that form, and it's a new form. A copy of that form is directly behind Form 21 in your materials. It's got a 2 checkbox appearance to it. To give notice that the 22E is due, buyer would mark the top box and deliver that to listing broker. When buyer does that, seller now has 3 days to respond by providing seller's Form 22E to the closing agent, copy to buyer's broker. If seller fails to do that, buyer can terminate the purchase and sale agreement. Buyer has a get out of jail free card, can terminate the purchase and sale agreement based purely on the fact that seller has not provided that Form 22E. Now, you might be thinking to yourself, yeah, who cares? Because no buyer in today's world is going to terminate any purchase and sale agreement. They worked way too hard to get to be the buyer in a purchase and sale agreement. They're not about to terminate it over a FERPTA issue. I disagree. Here's why I disagree. That same buyer who made an offer worked really hard to get to be the buyer, so hard, in fact, that they didn't include a financing contingency, didn't include an inspection contingency, didn't include any contingencies. Maybe even they made their earnest money non-refundable, whatever that means. If seller fails to provide the 22E following receipt of this notice from buyer, that means that buyer has from 3 days after delivery of this notice until either seller delivers the 22E or until closing to terminate the transaction and recover buyer's earnest money. Sellers, you better get the 22E delivered timely to cut off buyers' right to terminate the purchase and sale agreement. That's the first issue. Timing of this all of this is the second issue. The 10 days is significant because if you have a 25, 30-day closing, 10 days after mutual acceptance is hopefully still going to provide enough reaction time by escrow that they will be able to handle the situation if, in fact, the seller is a non-resident alien. Liz, questions?
Yes. Doesn't this mean we're going to have to follow up with escrow to make sure they receive the 22E?
Absolutely. Absolutely. You're going to follow up with escrow and make sure they receive the 22E. And then you're going to ask them to send you a copy of it so you have it for your transaction folder.
Okay.
Anything else?
Yes. So since the listing agreement says seller owes listing firm, let's say a total of 6%, buyer doesn't want dual agency and listing agent writes up and pens house. At close, 6% is listing firms, but does all...
Wait, Liz, wait. I need you to read the question without putting any percentages into the... I'm going to see if I can find the question in the chat box. Okay, there it is. This listing agreement says seller owes listing firm. Let's say X%. Buyer doesn't want dual agency and listing agent writes up and pens house. At close, X% is listing firms, but does all X% go to the listing broker or listing broker surrogate? Yeah, I mean, there's only... if the answer is yes. This has nothing to do with the revised form. This is all about the listing agreement between the listing firm and the seller. Whatever seller has agreed to pay the listing firm, it's earned by the listing firm. It's sent up to the listing firm to determine how that commission gets paid out, either to one broker in their firm or to share it between two separate offices. But seller owes the commission identified in the listing agreement, period, end of story. No more questions on that topic. Okay, Liz, go ahead. I'm sorry.
10 days seems like a very long time to give the sellers to comply and deliver this form. Curious why this is, since this really seems a seller duty and is important to protect buyers.
I agree with you. It should be handled before the property even hits the market. But the reason that the 10 days is given is because those 10 days immediately after mutual acceptance are usually consumed with all kinds of really important stuff, like buyers getting their inspection done, buyers applying for their loan. If they've got to sell a house, they've got to get it on the market. So buyer has got themselves occupied with all kinds of issues that maybe even seem more important to them than getting the FERP certificate. So immediately on the heels of all of that stuff happening, buyer brokers, you need to calendar your own files so that if you don't have the 22E by then, you remember the importance of discussing this with the buyer and having the buyer submit a 90 FERPTA if that's important to the buyer.
Okay. If it is on the attached docs, is that considered delivery?
If the FERPTA is uploaded as an attached document, does that constitute delivery? It kind of depends on the form we're talking about. But if we're talking about the 90 FERPTA, that's pretty simple because that means it's already there. And if buyer broker says, or buyer submits a 90 FERPTA and seller and listing broker have the 22E uploaded the whole time, it would be really simple for the listing broker to simply pull it off and deliver it straight to the escrow company. So the 22E needs to get to the escrow company. If it was uploaded as an attached document, it's a simple solution. If it hasn't gotten to the escrow company yet, listing broker just get it to the escrow company. That solves the problem. Buyer broker could do the same thing by pulling it off of the listing and delivering it to the escrow company. Anything else?
Yes, we have a question that says, why wasn't the 22E just made something in some supplemental documents as a necessary doc in order to list?
Every MLS has their own rules about what documents are required to list property. There's no statewide forms rules that require any seller to sign any document in order to list their property. So that would have to be an MLS by MLS issue.
Okay, and we have one last one. It says, but buyer at that point is out a bunch of money for all of the diligence they've done. Is there any sort of recompense available to the buyer if the seller then refuses to complete the FERPTA?
No, there's no There's no damages provision that says that buyer gets to recover anything from seller if seller refuses to provide the 22E to escrow. Okay.
So could I ask a question? Hello?
Okay. Yep. Go ahead.
Yeah. So yeah, I get it. From now on, we have to have a 22E on every purchase and sale. But if we have something pending right now, and it doesn't have the 22E and the box is checked, the seller's not a foreigner, we have to add that then? If it goes beyond March?
Yeah, it's a good idea for every buyer broker's firm to have a copy of the seller's 22E in their transaction folder as a kind of justification for buyer broker's reliance on that check mark box being marked the way it was on the face of Form 21. It's not a contract requirement. It's not a state law requirement. It's a good idea. Going forward after March 3rd, it may become a contract requirement because buyer may deliver the 90 FERPTA. As it stands, it's not a contract requirement. It's a very good idea for you to have it in your folder, though. Okay, let's go ahead and cover the computation of time provisions before we take a break, and then we will be finished with the changes to Form 21. Everything you know about the computation of time provision as it exists today still exists. None of the existing language in the computation of time provision, Form 21, has been modified. All that has changed is that we have added language to the computation of time provision, and the language that's added gives you a roadmap for counting time backwards. If you're familiar with the computation of time provision, you know that it tells you how to count time moving from the date of mutual acceptance forward, or from any triggering event forward. And we know that 5 days or less includes business days only, 6 days or more includes all calendar days. We know that no time period can end on a weekend or holiday unless there's very few exceptions to that. And we're not going to go into the exceptions in this class because it's not relevant to the changes that are made. And that if you have a time period that ends on a weekend or holiday, and that's not possible, then you automatically advance forward to the next business day that is not a weekend or holiday. So the revision to the computation of time provision now instructs parties as to how they count time backwards. Why do we have to add this very confusing concept to the computation of time provision? Because as the industry is evolving, we are finding ourselves with more and more time periods in the boilerplate language of the forms that time periods start at closing and move backwards from there. There are 3 examples given on this PowerPoint slide. In Form 22EF, a copy of which is in your materials behind the purchase and sale agreement, just for your reference, it is not being revised as part of these forms revisions. But if you look at Form 22EF, line 29, I believe it is a blank space under the buyer's contingent funds provision. And with that blank space, default days 10, so 10 days by default. Buyer has, let me back up. If buyer has marked the contingent funds provision, and let's say buyer has marked the box that says that buyer is going to convert funds from the stock market into liquidated funds in their bank account, then what that blank on line 29 says is that not more than 10 days prior to closing, buyer has to deliver to seller proof that those funds have been converted and they're in buyer's bank account. And if buyer fails to deliver that proof within that time period, seller can terminate the purchase and sale agreement. Seller's not required to deliver any notice that I'm going to terminate, doesn't have to give the buyer a chance to cure the default. Seller simply has the right to terminate the purchase and sale agreement if buyer, meaning buyer broker, has failed to deliver proof to seller by 10 days prior to closing that buyer's funds have been converted to cash and they're in buyer's bank account. In order to know when buyer's deadline is for making that proof, buyer broker, you need to count backwards from closing and make a note on your calendar at the time of mutual acceptance. Because if your buyer misses this date, seller can terminate the transaction. And in a market where seller might have a backup buyer willing to pay $20,000 more than your buyer's willing to pay, you better not make a mistake on counting these days. So the computation of time provision is revised to tell us how to count those days. Another example, Form 35 says that seller's repairs that seller agrees to make must be completed not less than 3 days prior to closing. And Form 21 has a built-in boilerplate provision that says every buyer is entitled to do a walkthrough of seller's home within 5 days prior to closing. So how do we count these time periods? Nothing has changed with respect to 5 days is business days only and 6 days or more is calendar days. So with respect to our Form 22EF provision, where we were talking about a 10-day provision, 10 days includes calendar days. When we're talking about buyer's walkthrough, which is 5 days, that's business days only. But no time period can end on a weekend or holiday. This is where it gets confusing. So if you're kind of drifting off, if you're reading your text messages, if you're looking through Instagram, stop and pay attention to what I'm about to say. When you're counting days backwards and you land on a weekend, the day that the event, the day that matters to your calculation, you're moving backwards, you stop at the weekend, and you move forward to the next business day that comes on the calendar. Intuitively, you might think that you would just keep moving backwards, right? If you land on a weekend or holiday, you're going to go to Friday. That's wrong. You're not going to go to Friday. You're going to go to the next day moving forward. That's not a weekend or holiday. Monday, unless Monday's a holiday, it will be Tuesday. Why did we do it in this goofy way? Because prior to this forms revision, we don't have a roadmap for counting backwards. So we're creating it right now for everybody to learn at the same time. So do we have any models anywhere that we could base on? And the answer is yes. Within the judicial system, within the court structure, the way court rules are created, when a court, let's say you have a trial date and you have to disclose who your witnesses are going to be X number of days prior to closing, you would count backwards from your trial date to figure out when your witness list is required. Let's say you're going to go argue a motion at the court. When is your briefing due? You're going to count backwards from the date that your motion is going to be argued to figure out when your briefing is going to be due. So judges, lawyers, judicial system, we have this mechanism for counting days backwards. And it means that when you land on a date that's a weekend or holiday, you move forward to the next day that's not. Let's practice. In your chat box, I'd like you to answer this question. Ready? Get ready to count with me. I mean, not with me. I want you to do it on your own. Closing is on a Wednesday. All right? Closing is on a Wednesday. Tell me what day of the week is the first day on which buyer can do their walkthrough based on their Form 21 right to do a walkthrough 5 days prior to closing. So count for me when buyer's 5-day walkthrough would begin, the right to do that walkthrough would begin if closing is on Wednesday. Write it into the chat box. Okay, we've got some confusion out there. The answer is Wednesday. Why? Because 5 days is business days only. Closing is on Wednesday. So day 1 is Tuesday. Day 2 is Monday. Business days only, so we don't count Sunday and Saturday. Day 3 is Friday. Day 4 is Thursday. Day 5 is Wednesday. The first day that buyer could do their walkthrough is Wednesday, the week before. Okay, now I want you to count the time period that's created by Form 22EF, line 29, default 10 days. Closing is on Wednesday. when you're the buyer broker, you got to make a notation on your calendar for when buyer's proof of funds is due to the listing broker. When is buyer's proof of funds due to listing broker? If closing is on Wednesday and we're counting a 10-day time period. Give me the day of the week and assume no holidays. You guys are so smart. Almost all of you got this correct. You counted your 10 days. You did Tuesday, Wednesday, Sunday, Saturday, Friday, Thursday. You went all the way back until you realized that the 10th day landed on a Sunday. And you knew that no time period can end on a weekend or holiday. So it can't be due. Buyer's notice can't be due on Sunday. So then the question is, what day is it due if it's not due on a Sunday? Most of you knew that you advance forward and buyer's notice is due on Monday. And the first time I taught this class a week or so ago, somebody gave me a really handy reference tool, and I think this makes sense, and I think that you should all try to remember this. When you're counting days forward from mutual acceptance, landing on a weekend or holiday means that the time period is necessarily going to expand. It's always going to get bigger. It can never get shorter. When you're counting days forward, your time period is always going to expand when you land on a weekend or holiday. When you're counting days from closing, the exact opposite is true. Your time period can never expand by landing on a weekend or holiday. It can only get smaller. It can only contract, draw closer to closing. So time periods moving forward can expand, but time periods moving backwards can only get smaller. Okay, Kara, you probably lost any questions in the chat box deep in the answers to those questions, but do you have any that you know of,
Yes,
questions related to that?
We sure do. And first one is, does the 22E going into the actual PSA, or does the 22E go into the actual PSA or just separate to escrow and buyer's firm file? It's kind of backtracking a little bit.
Oh, the 22E, I think I understand the question. The 22E, the purchase certificate, is never, ever part of the purchase and sale agreement. It goes to escrow and it should be retained in the firm's transaction folders. I think that was the question, right?
Yes. And then the second one for 22EF, does the proof of funds need to be delivered to seller exactly 10 days prior to close?
It says, I'm looking at the language, buyer shall provide evidence to seller 10 days prior to closing that the funds relied in section has been received. So 10 days. So it can't be less than 10 days prior to closing. It could be more than 10 days prior to closing. But it can, if it's not delivered by that 10th day prior to closing, which based on our computation of time would be Monday, if it's not delivered by that date, seller has the right to terminate. We're going to start with the financing addendum, Form 22A, and we will talk about the technical changes to the form. But before we talk about the change in the language itself, I want to talk to you about philosophies associated with the financing addendum, because the revisions to the financing addendum incorporate an entirely new philosophy. The philosophy established by the existing financing contingency, and you can still opt for this philosophy in the new revised form, but then I'm going to explain another philosophy to you in a minute, and in the revised form, you're going to have the option of two different philosophies. The philosophy with which you're all familiar already is a philosophy that says the financing contingency never, ever, 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 ever expires by its own terms. The only reason that the financing contingency would ever fail to protect the buyer prior to closing is if the buyer waives the financing contingency. And the only reason a buyer would ever waive the financing contingency is because seller delivers a notice that advises the buyer to either waive the financing contingency or seller will have the right to terminate the purchase and sale agreement. That's our existing Form 22A. If you want that approach to the financing contingency, you can still get it. You will find it in the revised form, paragraph 2, option A, which specifically says that buyer has a financing contingency that lasts all the way to and through the closing date. The survival language is still in the financing contingency, meaning that if buyer fails to provide the notice, either terminating pursuant to the financing contingency or required by the financing contingency to recover the earnest money, buyer's right to recover the earnest money based on the financing contingency survives the termination of the purchase and sale agreement, and buyer can recover their earnest money based on the financing contingency days, weeks, months, years after the sale failed closing date if buyer delivers the lender letter necessary for buyer to recover the earnest money. All of that is housed in paragraph 2, option A of the new form. The nuts and bolts of that provision says that if seller wants to force buyer to waive buyer's financing contingency, the default number of days is now 21 instead of 30. If you don't put anything in the blank, then 21 days following mutual acceptance, seller may deliver to buyer a 22AR. The paragraph in 22AR is no longer entitled Notice of Right to Terminate. It's now entitled Notice to Perform, thought to be a little kinder and gentler, and maybe more representative of what the seller is asking for. Buyer, either let me know that you are going to perform the purchase and sale agreement by waiving your financing contingency, and if you don't do that, then I have the right, but not the obligation, to terminate the transaction. And buyer, you have no idea whether I've got a backup buyer or not who would like to pay me more money to purchase the property. So it behooves you to think critically as to whether or not you will, upon receipt of my notice, waive your financing contingency. And in paragraph 2A3, Roman numeral 3, the little i's, in that provision, the buyer who waives their financing contingency in response to seller's delivery of notice to perform can retain the protection of the low appraisal provision housed within the financing contingency if they either mark no box or mark the will not box. The change from the current form to the new form with respect to this option A philosophy is that the protection of buyer's low appraisal provision in the existing form, the default is for waiver of the low appraisal provision. In the revised form, the default is for the protection of the low appraisal provision. So if you do nothing at all and buyer waives their financing contingency, their option A financing contingency, in response to seller's delivery of a notice to perform, if you do nothing at all in that small Roman numeral 3 provision, buyer will retain the protection of their low appraisal provision. Okay, that is the revised form, paragraph 2, option A, which incorporates the philosophy of the financing contingency with which you have always in Washington State been familiar. So what is housed in paragraph 2, option B? What we find there is an entirely new philosophy, and it is a philosophy that says that the buyer's financing contingency will automatically waive following the passage of an agreed number of days, 21 by default. Option B says that the financing contingency, like the inspection contingency, like the title review contingency, like the homeowner association document review contingency, like every single other contingency contained in the statewide form system, the financing contingency will expire on a date certain if prior to that date, buyer has not terminated the purchase and sale agreement. If prior to the automatic waiver date of the financing contingency, buyer terminates the purchase and sale agreement, buyer will recover buyer's earnest money if and only if buyer can provide the lender letter required in order for buyer to recover the earnest money. It is the same lender letter, whether you're operating under option A or option B. The lender letter is the exact same lender letter that's required under today's form. It is described in exactly the same terms as it is in today's form, but it's set forth in paragraph 4 in the revised form. And the revised lender letter must include the date that the buyer made loan application, has to have been timely loan application, must provide that the buyer had sufficient funds to close the transaction, and it has to identify the reason that loan funds would be unavailable on the date of closing. Buyer brokers, if I could, kind of grab you by the shirt collar right now, the virtual shirt collar, and shake and make sure you're paying attention, this would be the time to do that. If your buyer uses option B, it is absolutely critical that you as buyer broker take control of the situation to communicate clearly to the buyer the utter and absolute importance of 3 things. Buyer, I cannot overstate these 3 things. If you are going to have a financing contingency that automatically waives, you must do these 3 things. Number 1, you must hire a competent lender. More to come. Second, you must timely submit all of the documentation requested of your lender. And I mean, immediately upon them requesting it, you deliver it back to the lender. You don't take 3 weeks to find your tax returns. You deliver them the next day after the lender tells you they need them. And number 3, you press your lender to prepare the loan package and submit it to underwriting. We cannot wait to submit to the underwriter. You've got to get it there even before the appraisal is in, if that's required. So let's go back to number 1, hire a competent lender. You tell your buyer, look, here are 5, 10, 15, however many lenders you know that are abundantly capable of timely delivering buyers' loan funds. Buyer, I can't encourage you enough to select your lender from among one of these that I'm recommending to you. And buyer says, thank you, I appreciate the recommendation, but honestly, my cousin Fred in St. Louis does loans, and he said he could do one for me. Or I found this lender online, and they guarantee that my loan will be available in time for closing, or whatever else the buyer tells you. Then you need to pick them up by the virtual shirt collar and shake them a little bit and say, buyer, I don't know how to impress this upon you with greater emphasis, but I've been in this business, and then you can tell them however many years you've been in the business, or maybe if you haven't been in the business a lot of years, maybe you want to say, my firm has been in this business for a gajillion years, and here's our experience. There are a whole bunch of lenders out there who make a whole bunch of promises. But if your lender doesn't deliver, and we'll define deliver in a minute. If they don't deliver within 21 days, then buyer, you're going to lose your earnest money, because we have to have an answer from their underwriter. That's what we mean by delivery. They've got to get the loan package submitted, and we've got to have an answer from the underwriter. Because if the answer is no, then that answer will be embedded into the letter that they send that we can then use to recover your earnest money. But if we don't have an answer from their underwriter, and so you say, I'm just going to terminate the transaction then because I can't take the risk that my lender will actually perform in time, then buyer, you're not going to get your earnest money back. Because the only thing the lender's going to be able to say is the reason the loan wasn't available is that you abandoned the loan application or you terminated the transaction. And that's not a good faith reason for you to recover your earnest money based on the financing contingency. Buyer, you have got to hire a competent lender. I cannot speak on behalf of any of those lenders that I don't know, and I can't even promise you what my lenders will do, but I trust these lenders to do a good job. And here's what else I can tell you. If there's something happening that's going wrong in your transaction, in the loan processing, we can go knock on their door and have a face-to-face with this lender because I know them. And this lender is incentivized to do a good job because they know they want more business from my buyers in the future. And they're not going to get more business from my buyers if they don't do a good job for you, buyer. You've got to hire a competent lender. You've got to get your documentation submitted timely, and we've got to get submitted to underwriting quickly. That's what option B of Form 22A, paragraph 2 says. Same low appraisal protection provision. This time it's paragraph 2B, Roman numeral 2. Same thing though. You want the will not box checked if you're trying to protect the low appraisal, or leave it, don't mark any box because it's will not by default. Okay, questions?
Yes, there's a couple. What happens if they choose option A and the lender is slow and cannot close on time?
If they choose option A and the lender is slow and can't close on time, so long as they get their letter from the lender saying the reason the loan funds weren't available is because the lender didn't process the loan timely, but they made timely loan application and they had sufficient funds to close the transaction, they should recover their earnest money.
Okay. Isn't it true that they only lose their earnest money if they fail to close?
I have no idea. The answer to this question is controlled by how the parties mark the seller's remedies provision on the face of Form 21.
Okay. Similar to inspector disclosure, is there a lender disclosure?
No, there's not. The question is asking about Form 41B. No, 41A is the agency disclosure. I can't remember what the, see, this is where I miss a live class because somebody out there in Zoom land is shouting out the number of the form for the inspector referral, which I can't remember right now. But the question is asking about that, and it's probably flashing in the chat box. Let's see. Form 41D, thank you. Form 41D is the inspector referral form. We have no similar form for lender referrals. If your firm wanted to come up with a form associated with making referrals for lenders, then they could certainly do that, but there is no standardized form for that. The reason Form 41D exists is because there is a licensing law provision that says that disclosure must be made, and so we have a form to be consistent with that licensing law requirement. Anything else?
Yeah. Well, why would the buyer ever select option B?
Maybe the buyer wouldn't. Maybe the buyer would select option A and seller would counter with option B. And the reason why I think that we are going to see some transactions with option B is because right now, and I could be way off, you know, I get to live in the ivory tower and I get to speculate about what's going to happen, but I'm not actually on the ground making transactions happen. So I could be way off in my guess of what might happen. But to me, option B feels kind of like a middle road. If you're only familiar with option A, then it's probably option B probably feels like it's the opposite end of the spectrum. But I kind of feel like option A is here, option B is here, and no financing contingency at all is over here at the other end of the spectrum. Option B might be a nice middle ground for the buyer, for this, when a seller is saying, look, buyer, this financing contingency drives me crazy because you're going to have a financing contingency all the way to closing if we use 22A. Maybe listing broker and buyer broker communicating with their clients could get the parties to a middle ground position of saying, look, give me 21 days to work with a competent lender to find out if I can get financing. You're going to know, seller, within 21 days whether or not I can get financing because my financing contingency is going to go away whether I get it or not. So can we agree to this middle ground position rather than me having to waive my financing contingency altogether? We're going to see why buyers or sellers might pick option B. Maybe nobody will, and maybe at the next forms revision, if that's the case, then we'll eliminate option B and we'll go back to just keeping option A. We'll have to see what happens. Anything else?
What happens in the case if financing is waived and the transaction doesn't close due to the fault of the seller? Example, title issue.
The finance. So this question is apples and oranges. If the seller fails to close because they don't have either marketable title or they can't procure title insurance to insure their warranty deed, then Form 21, boilerplate language in Form 21 says that the buyer recovers their earnest money. Has nothing to do with whether or not buyer has a financing contingency. If buyer has a financing contingency, it protects buyer in the event they're unable after a good faith effort to obtain to obtain financing. So financing and seller providing clear title are wholly separate issues and they have nothing to do with each other.
If listing broker has had a bad experience with the buyer's lender, they can choose to not accept the offer, or seller asks buyer to choose a different lender.
So let's be careful with our wording there. If I heard it correctly, the question said, if listing broker has had a bad experience with buyer's lender, they can choose not to accept the offer. Of course, that's not true, but listing broker could certainly, absolutely advise the seller, this buyer wants a financing contingency, and they're utilizing a lender with whom I've had very bad experiences. I have reason to believe that this lender is not going to perform as they say they will. And if you want to do business with this buyer and give this buyer a financing contingency, there's no reason that you can't say, I will only give you a financing contingency if you select a different lender. A seller certainly can say that. Anything else?
One more question. If buyer has done everything needed, but lender does not get it done by the closing date, you are saying that if the closing date is missed and the seller won't close, does the buyer get their earnest money back?
I'm sorry, Liz, are we on option A or option B, did it say?
It doesn't say.
Okay, so that matters. If we're talking about option A and we get all the way through the closing date and the sale fails to close and the buyer can get the lender letter, the adequate lender letter showing that buyer made a good faith effort, then under option A, if seller has not required buyer to waive the financing contingency, then buyer should recover their earnest money. Under option B, buyer is going to be in breach, forfeit their earnest money because they no longer have a financing contingency. Okay, so what about the rest of the form? The rest of the form has some minor changes. If you'll think about the current form, paragraph 2 is the loan information, paragraph 2 from the existing form 22A. And one of the really important provisions of the loan information provision is that it allows the buyer and seller to negotiate for buyer's authorization for seller and listing broker to be able to communicate with buyer's lender about the status of buyer's loan. That boilerplate language is now embedded at the very end of paragraph 1B in Form 22A, the revised Form 22A. So that authorization for listing broker and seller to communicate with buyer's lender is part of the revised Form 22A. It is part of buyer's offer if buyer includes a Form 22A in buyer's offer with either option box checked. Just by including the Form 22A, buyer authorizes seller and listing broker to maintain status with buyer's lender. Listing brokers, you better be doing that. You're not doing your job on behalf of your seller if you're not staying in touch with buyer's lender to know the status of buyer's loan. We now have the exact language from the amendatory clause, the VA amendatory clause embedded in the financing contingency. We also have language, it was in there before, it's still in there, requiring the parties to sign any other amendatory clause that may be required by buyer's lender. There are no changes in the financing contingency to the paragraph 1 buyer loan application requirements, to the low appraisal provision, or to the loan cost where the buyer asks the seller to pay their loan cost, to that provision. There are no changes to any of those very significant provisions within the Form 22A. Okay, Form 22AD, the increased down payment addendum. It seems goofy that the 22AD is the increased down payment addendum, and the reason why it's not the 22ID is because the 22AD used to be entitled the additional down payment addendum. A revision or two ago, it changed to the increased down payment addendum, but that's why the form is identified as 22AD. There are two sections to the revised 22AD. There's a paragraph 1 and there's a paragraph 2. Paragraph 1 is exactly the same as the existing Form 22AD. And it says right on the face of the language that the language in 22AD, paragraph 1, replaces the low appraisal provision of of the financing contingency, Form 22A. So if you have a Form 22A in the transaction, and if you have a 22AD in the transaction, the 22AD replaces the low appraisal provision of the Form 22A. So if the parties have agreed on Form 22A that even in the event buyer waives their financing contingency, buyer will retain the protection of the low appraisal provision. What buyer is saying is that buyer is retaining now the protection of the additional down payment addendum, because the additional down payment addendum replaces the low appraisal provision from Form 22A. So what does 22AD say? 22AD says, from buyer to seller, hey seller, the purchase price is here. And if my appraisal comes in here below the purchase price, I'm going to make up the difference so long as the difference is not greater than X. So purchase price is $450. If the appraisal, and I'm going to bring to closing, I'm going to bring whatever my down payment is that's required. But I'm also telling you, seller, that if the appraisal is low, I'm going to bring an extra $20,000 to closing to make up for a low appraisal, so long as the appraisal isn't lower than $430,000, because we got a purchase price of $450. So if the appraisal is $430, I'm going to bring that $20,000 difference to make up the difference to the closing, to make up the difference to the purchase price, and we are going to close this transaction. But 22AD goes on to say, if the difference between the appraised value and the purchase price is greater than whatever amount I agree to bring to closing plus my down payment, then I don't have to close the transaction, seller. That's what 22AD says. And in fact, 22AD goes on to say that if the appraisal is here and the purchase price is here and I'm bringing this much and it does not get me to the purchase price, then buyer must, not may, buyer must deliver notice to seller that the appraisal is low and that the difference in the amount that buyer is going to bring to the table isn't enough to make it up. And buyer must give notice to seller, and once seller receives notice, seller can do one of only two things. Seller can either lower the purchase price to the appraised value plus the additional down, or seller can terminate the transaction. That's it. Those are seller's only choices. How can buyer prevent seller from terminating the transaction? The only way buyer can prevent seller from terminating the transaction, based on paragraph 1 of Form 22AD, is to waive the financing contingency. If buyer waives the financing contingency, then seller cannot terminate the purchase and sale agreement because the appraisal plus the difference doesn't meet the purchase price. Because instead, by waiving the financing contingency, what buyer is saying is, don't worry about my 22AD, seller. I'm going to bring whatever the difference is between appraisal and purchase price in addition to my down payment so that the transaction can close. Now, I want you to pay attention to lines 17 through 19 of the 22AD. In order to accomplish that outcome, where buyer can waive the financing contingency and prevent the seller from terminating, there's language embedded in the boilerplate, and it's housed in lines 17 to 19. And it says, if buyer waives the financing contingency in the financing addendum, buyer shall be obligated to shall be obligated to purchase the property for the purchase price, and seller shall not have the right to terminate the agreement. Fine. That's what the agreement, that's what Form 22AD has always said. But now I want you to think about that language. If buyer waives the financing contingency in the financing addendum, buyer shall be obligated to purchase the property for the purchase price. What if you have a buyer who had a Form 22A in the transaction, marked option B, and their financing contingency automatically waived, even though they retained the protection of the low appraisal provision? If they have a 22AD in the transaction, 22AD says on its boilerplate face, if you waive the financing contingency, you close the transaction, and 22AD has no meaning. This was not the intention of the forms drafters. It is too late to change this form at this point. The ship has sailed. And so what you need to know as a forms user going forward with this form is that if your buyer is going to waive the financing contingency, either because they marked option B or because you're in a marketplace where sellers are delivering that notice to perform and your buyer's going to be faced with either having to waive the financing contingency even under option A or terminate the transaction, allow seller to terminate the transaction, then buyer brokers, if your buyer is going to have a financing contingency 22A and likely waive it, you do not want a 22AD in the transaction. You want to live with a low appraisal provision. Because otherwise, if you have a 22AD in the transaction, what it's effectively saying, and I shouldn't even say it that way. You know what? That's not the right way to introduce this. You need to make sure that the buyer understands the risk. If you have a 22AD in the transaction, then that means that when buyer waives their financing contingency, they must close the transaction regardless of the protection built into 22AD because the low appraisal provision is effectively waived. Maybe buyer still wants to do that because maybe buyer needs to give seller confidence. Look, I'm going to bring extra money to the table if I need to, if the appraisal comes in low. Maybe buyer wants that provision in their purchase and sale agreement, and so maybe they want to include the 22AD. You just have to make sure they understand this risk. The bottom half of 22AD is the new portion of this form, and it is the same exact language, but it now applies to Form 22AA, the appraisal addendum. What is the appraisal addendum? It hasn't been revised, but it's in your form so that you can see what it says. Form 22AA is the appraisal addendum. It would be the form that a buyer would use in one of two circumstances. Either they don't need financing, so they don't include a 22A at all, but they still want to have an appraisal done so that they can be assured of the value of the property, or they do need financing, but they don't want a financing contingency in order to make their offer more competitive, but they do need the appraisal, and so they include a 22AA in order to protect the appraised value of the property for their loan. Those would be one of the two reasons that they would include a 22AA in the transaction. And the 22AA goes on to say that if the appraisal comes in low, buyer can terminate the transaction. So if you have a 22AA in the transaction, buyer may also want to include a 22AD. The AD would say that even if the appraisal comes in low, I'll bring in X amount to get up to the purchase price. If we don't get to the purchase price, then I can terminate the transaction. You can, again, avoid the obligation to deliver notice to seller, which would give seller the ability to terminate the transaction by waiving the appraisal addendum. You don't have the same risks associated with waiving the appraisal addendum because buyer is going to intentionally waive the appraisal addendum if that's what they choose to do. Okay, are there questions?
Yes, but why is that permission in the waiver clause only?
I don't understand that question.
Okay,
Why
Gabrielle.
is that permission? Gabriel, can you ask that question? Can you give me a little bit more explanation on what your question is? But why is that permission in the waiver clause only?
I'm talking about the permission to interact with the buyer's lender. So if you're the listing, if you're the seller, the listing agent, you want to be in contact with the buyer's lender. The permission to do so is sitting inside of the waiver clause in the 22A.
No, it's not. It's in Form 22A, lines 20.
It's sitting in line 21, 22, 23.
It's 22 through 24. It says buyer authorizes listing broker and seller to inquire about the status of buyer's loan approval with lender anytime prior to closing. That's all it says.
Inside that waiver financing contingency paragraph. So my concern was that would only occur if you were taking care of that way. If you were concerned about waiving the financing contingency, that would be the only time you'd be able to do that. No?
No, that paragraph is entitled waiver financing contingency because it's telling the buyer all the things they could do wrong that would inadvertently waive the financing contingency. And by the way, seller's going to be checking up to make sure, listing broker is going to be checking up to make sure you didn't waive the financing contingency by making your loan application timely, by applying for the right kind of loan, et cetera, et cetera. But it's not, I mean, the language is simple. Listing broker and seller, buyer authorizes listing broker and seller to inquire about the status of buyer's loan approval with lender anytime prior to closing, period. It's not attached to any other requirement.
Okay.
Anything else?
Form 22AD on line 8, to write in the amount of additional down payment buyer is willing to pay or total appraisal price.
On line 8, you would write in the amount the buyer shall pay additional funds up to. So that would be the X that I've been talking about. The buyer saying, look, I'm going to get a 10% down, 10%, loan to value loan down. I'm sorry, that would be a 90% loan to value. I'm going to bring 10% as my down payment. Let's say that 10% was for $40,000. The amount that buyer would write on line 8 would be anything over that $40,000, over the down payment that buyer is required to pay in order to secure their loan. What more amount of cash will buyer bring to closing in order to make up for a low appraisal? That's the amount of money that you write on line 822AD.
Okay, and one more question. Could you give a brief example with this conundrum between the forms 22A and 22AD? The explanation was a wee fast for me. Thanks.
So I'm just going to explain it again, and I understand that it is confusing. So let's say that we have a buyer, a Form 22A financing contingency buyer. And just to be simple, let's say that they're an option B buyer and that their financing contingency automatically waives on the 21st day. And they have a 22AD in the transaction because it was a competitive scenario and the price was bid up over the list price by $40,000. And so the buyer said, look, I don't have $40,000, but I have $20,000. And so seller, I'll bring $20,000 over the list price, over the appraised value to try and get to the purchase price if my appraisal comes in low. So buyer has Form 22A, let's just say they mark option B, and they have a 22AD, and on line 8, they write $20,000. And on Form 22A, paragraph 2B, Roman numeral 2, buyer preserves their low appraisal provision so that when their financing contingency waives, they know they're still protected if that appraisal comes in low. What I'm telling you right now is because they have the 22AD in the transaction, they're really not protected when that appraisal comes in low. That's the effect of having the 22AD. How come? How do we get there? Because in our scenario, buyer is agreeing to bring $20,000 extra to the closing table if necessary. So let's say that our purchase price was $250, buyer's appraisal comes in at $210. Buyer's only obligated to bring $20,000, so that will get them to $230. We're still $20,000 short of the $250 purchase price. The language in 22AD, line 17, says that if buyer waives the financing contingency in the financing addendum, which this buyer will have done because their financing contingency expired on day or waived on day 21, and let's say it's day 25 before they get their appraisal, and the appraisal is low, the Form 22AD will not give the buyer the ability to terminate the transaction because $210,000 plus $20,000 is still less than $250,000. Instead, Form 22AD says, buyer, because your financing contingency waived, you're automatically required to bring whatever is necessary to close this transaction to the closing table. Okay, that's it for Form 22AD. I'm sorry, I forgot to advance to the second slide when we were talking about Form 22AA. This is all the stuff we talked about for Form 22AA. The one thing that I didn't mention is that there is a new notice form, Form 22ADN, which is available for you to use to give notice for any of the notices that are required under the 22AD. Okay, I have a little piece of good news for you. the buyer's sale of property contingency, Form 22B. Whenever I teach a forms class, I always start out the discussion about Form 22B by saying this is the singularly most complicated form in the entire statewide form system, which is still true. It's a very complicated form. But the good news is that the revisions are not complicated. The revisions to Form 22B are clarifications only. Form 22B has always said that if the buyer waives the home sale contingency, buyer also automatically waives every other contingency benefiting buyer and agrees to close the transaction in 30 days. Apparently, it wasn't said clearly enough on Form 22B before because it was confusing to some people, and so that statement is made even more clearly in the revised Form 22B. Substantively, no different. It's just restated. There was two kind of conflicting and confusing statements on the old Form 22B or the existing Form 22B, and those have been corrected to make it very, very clear that if the buyer's sale fails at a time when the home sale contingency has already expired, then in that situation, buyer has the option of waiving the home sale contingency and proceeding with the purchase of seller's property. There was kind of conflicting and confusing provisions in Form 22B about that issue before. It's now made clear that that is the right buyer has. Optional clauses addendum, very minor revisions only. Paragraph 5, the utilities provision. A checkbox has been included for cable, and a checkbox has been included for internet, and a space to identify the provider for each of those utilities. The lead-based paint addendum has some changes to it at the request of the Environmental Protection Agency, and I shouldn't really say at their request. Instead, we learned through some audits that they did in some communities over on the border with Idaho, primarily Pullman, that the auditors were viewing the 22J as defective in some way. It's not. It's entirely consistent with the federal law. But the EPA was interpreting the federal law to say that buyer has to acknowledge by separate buyer initial provisions these two statements. So Form 22J has had two changes to it. The lease provision, in order to just kind of make it a simpler form, we've divided the sale component of Form 22J and the lease component of Form 22J into two separate forms. So there's now a Form 22J and a Form 22J lease. Property managers, you're going to use Form 22J lease with residential rental properties that were built prior to 1978. Sale properties, you're going to continue to use Form 22J, and what I want you to notice, because you'll miss it if you're not paying attention, is that at the top of page 2 on Form 22J, there are now these two new checkbox provisions. Make sure your buyer reads them. Make sure your buyer initials them. Don't overlook them. The septic contingencies, Form 22S, Form 22S King, Thurston, and the 22LA were all revised not to make a substantive change, but to make clearer what has always been the case. Buyer has the right, under all of the septic contingencies built into the statewide forms, to terminate for any reason or no reason at all within their septic contingency time period. It has always been a subjective contingency. It still is. We made that more clear because apparently it was confusing. What I want to make sure you know about the septic contingencies, because I see this as an error through the hotline from time to time, is that buyer's septic contingency doesn't even begin to run until seller has delivered the septic report. So for the seller who's dragging their feet in getting the septic tank pumped if necessary, getting it inspected, and getting that septic report, all you're doing is giving the buyer an extended septic contingency right, an extended right to terminate for any reason or no reason at all, because buyer's septic contingency period does not begin to run until seller has delivered that septic report. Questions, Liz?
Yes, for 22J, does buyer still have to initial received copies of all info listed above if no info was actually given?
So that's an interesting question that we have contemplated with brokers down in Oregon, because Oregon has a form with these provisions in it already. And Oregon has instructed brokers in Oregon, don't initial these boxes if the seller hasn't provided anything. When I was teaching the form before, an Oregon broker told me that that's what they were learning in Oregon. I said, sure, initial those boxes, whether seller provides anything or not, because what the question asks is, has buyer received copies of all information listed above? And when you read seller's report above, seller's disclosure, there's a mark that says, seller has no reports or records pertaining to lead-based paint and or lead-based paint hazards in the housing. So in other words, seller is not going to deliver anything except for the disclosure that seller has no information. So I say, sure, mark the box that says buyers receive copies of all information listed above. The only information listed above is that seller has no documents they're going to provide. In reality, and so the Oregon brokers say, whoa, that's the opposite of what our Oregon lawyers told us to do, and it's the exact same federal government. So who's right, Washington or Oregon's lawyer? And so ultimately I come down on the side of saying, let your buyer read the form and mark the box if they want to. I don't really care. The boxes are there. The form is now consistent with the EPA's requirements. Let your buyer read the form, and if they believe that they should initial that they've received information, great, initial it. And if all that they're receiving is the seller's representation that the seller has no information, then they've still made a consistent set of initials with that disclosure from the seller. And if they say, you know what, I didn't receive any information, so I don't want to initial there, okay, that's fine. The form is still compliant with EPA's requirements. Anything else?
Yes. If seller checks no to having lead reports, why would buyer initial they had received the listed information above? I think you said buyers would need to check that line either way.
Okay, so that was the question we just answered.
Form 22S, as a listing agent, can I instruct buyers to sign a form waiving septic contingency when they submit offer, provided I provide septic paperwork to them in advance? Which form?
I'm sorry, I got to read that question. Form 22S, as a listing agent, can I instruct buyers to sign a form waiving septic contingency when they submit offer, provided I provide septic paperwork to them in advance? So let's start with the real basic. As a listing agent, can I instruct buyers? No, listing agent, you have no authority in this transaction. Your sellers can set terms of agreement to which they will agree, and if they will not agree to include a septic contingency benefiting the buyer in the purchase and sale agreement, then so be it. The parties are going to have to negotiate around that. Nevertheless, in most counties in the state, at least in many counties in the state, seller has all kinds of septic obligations that are predicated on seller conveying title to the property. So whether you have a septic contingency or not, seller has all kinds of performance obligations associated with the septic system. If there is a septic system, you may not really be saving your seller a whole lot of grief by having the septic contingency in there. In fact, in some respects, I think the septic contingency is a good roadmap for you to be able to point to the seller and say, you've got to do this. You got to do it now. Do it while the buyer is still in love with the property. Get this contingency resolved by performing your local ordinance obligations with respect to your septic contingency. Okay, anything else, Liz?
Yes. On 22J, has cancellation rights been removed for buyer? What happens if seller does not provide 22J?
The cancellation rights for the buyer associated with the seller not providing the 22J are housed in the Form 21. They always have been. They still are. It's every single buyer who uses the Form 21 every single buyer who's entitled to receive the lead-based paint disclosure has 3 days following receipt of the lead-based paint disclosure if the 22J is not part of the originally negotiated purchase and sale agreement. I think that provision is housed on the last page of the Form 21. It's under its own separate heading regarding lead-based paint disclosure. Anything else?
Yes. Why does the lead form not have a timeline for seller to deliver lead reports if box was checked yes, they have lead reports?
The form is entirely consistent with the federal legislation. So if it doesn't have the timeframes on it that you think it needs to have, then that's an issue that you need to bring up with your congresspeople, because the form has includes the requirements that the law requires of the seller. Best answer I can give you. It's not a form over which it's a little different than the Form 17 because the language is not dictated by statute, but our hands are tied with the creation of the Form 22J issues. They are entirely dictated by federal law. We don't create the standards that are set forth in Form 22J. Okay, really quickly, before we take another break, I want to talk about the last form that we're going to discuss with minor revisions, and that is the Title Contingency Addendum. Title Contingency Addendum 22T says that if buyer receives the preliminary commitment for title, a copy of the preliminary commitment for title prior to mutual acceptance, then buyer's right to terminate under the 22T begins to run at mutual acceptance, not prior. My question to you, listing brokers, is if you have acted competently to upload to the MLS printout the preliminary commitment and all documentation supporting the preliminary commitment, such as CC&Rs, then I want you to think critically about whether or not a buyer really needs a 22T, or is the buyer simply trying to grab another opportunity to terminate the transaction for any reason or no reason at all? And your best suggestion to the seller to be to think critically about whether or not this buyer really needs a Form 22T Title Contingency Addendum. And I know people will say, yeah, there could be amendments to the preliminary commitment that change title. And my response to you would be possible, but extraordinarily rare in your garden variety residential transaction. It happens from time to time, certainly in commercial transactions, it happens more often. But in your garden variety residential transaction, more often than not, the title commitment on which the title policy is based is the same preliminary commitment for title that was issued prior to the listing. Not in every case, I know, but more often than not. So is seller going to deliver a title contingency to the buyer based on the one-off type of scenario, or on the garden variety scenario where buyer only would be getting an opportunity to terminate for any reason or no reason at all after they've already entered the purchase and sale agreement? And I'm not telling you there's a right or wrong. I'm telling you in this scenario, you should think critically about whether or not the buyer really needs that 22T. Okay, is that a question on this topic, Liz?
Do you recommend upload to supplement documents like CC&R, even if the title includes hot links to those documents?
However the buyer can access them. I recommend that you create a scenario where the buyer can access those documents. So if it's through hot links, I don't have a problem with that, but the buyer needs to be able to access those documents. The inspection addendum, Form 35, has had some significant revisions to it. The first has to do with who is allowed to inspect the property and when. So I want you to put in your mind the way the form is structured with the contingency periods, the inspection periods. The inspection addendum Form 35 includes an initial inspection period, which by default is 10 days, and an additional inspection period, which by default is 5 days. And what the current form says is that during the initial inspection period, buyer can always do their own home inspection, okay? So set that aside for a moment. So everybody knows buyer can always do their own inspection. So we're gonna not talk about that. We're talking about who buyer can bring into the home other than themselves to do inspections. That's all we're talking about. And what the current form says is that during the initial inspection, the only people buyer can bring into seller's home are people who are licensed consistently with the Home Inspector Act, the Home Inspector Statute. And what the Home Inspector Statute says is that the only people who can do a general home inspection are licensed home inspectors. And in addition, people who are licensed electricians can inspect electrical systems. People who are licensed plumbers can inspect plumbing systems. Licensed engineers can look at the structural integrity of a building, et cetera, et cetera. Those are the only exceptions. A licensed pest inspector, I think there's one more. But it's licensed individuals who, actually, I'm not going to say that. It's licensed electrician, plumber, engineer, pest. Let's stick with those. The one category of professional, licensed professional, who is not exempt from the home inspector statute and therefore under the current form is not allowed as a matter of right into seller's home during the initial inspection period is a contractor. Could be a roofing contractor, it could be a mold abatement contractor, it could be a general contractor. A person with a contractor's license is not categorically exempt under the home inspector statute, like a licensed electrician or a licensed plumber or a licensed engineer or a licensed pest inspector. Which means that under the current form, the only time that the buyer has an automatic right to bring a contractor in is during the additional inspection period, when the language of the form says that buyer has the right to bring specialists into seller's home, no requirements pertaining to the home inspector statute. So under the existing form, buyer can have their home inspection in their initial inspection period, and then if they need bids from a contractor to support the work that the inspector has recommended, they've only got, as a matter of right, the time during the additional inspection period to get those contractors into seller's home. With the form's revision, we've still got the initial and the additional inspection time period, but now those time periods only affect timing. They don't affect who can come into the property. So during the initial inspection period and during the additional inspection period, by signing the Form 35, seller consents to buyer bringing in a licensed home inspector to do the general home inspection. A licensed inspector is the only person under Washington law who can do a general home inspection. But during the initial inspection period and during the additional home inspection period, buyer can also bring an electrician, a plumber, an engineer, a pest inspector, a roof contractor, a general contractor, a mold abate, any other contractor, anybody who's deemed a specialist to evaluate the work that needs to be done on seller's property. And the only difference now between the initial inspection period and the additional inspection period is the amount of time available. If buyer needs to trigger the additional inspection time period, buyer still triggers the additional inspection time period in exactly the same way that they would trigger it today. They would provide the seller with a Form 35R, marking the box for additional time, and they would accompany that form with the recommendation, not the whole inspection report, not even multiple pages from the inspection report, but only the portion of the inspection report that sets forth the inspections themselves that are recommended by, the additional inspections that are recommended by the general home inspector, the licensed home inspector who inspected seller's home. If buyer does their own home inspection, they are going to have to write recommendations for additional inspections that they would attach to the Form 35R, triggering the additional inspection time. Okay. I want you to keep that in your mind, that buyer triggers the additional inspections by attaching to the Form 35R only the recommendation from the inspector. And if the inspector's recommendation is embedded in a whole bunch of other stuff, then I would suggest that buyer broker, you ask the inspector to give you a page of just the inspection recommendations so that buyer has a clean page of just the inspection recommendations that buyer can attach to the Form 35R. More and more inspectors are doing that already. If your inspector's not doing that, ask them to write their inspection report in that way so that you have a separate page with the additional inspections on that page. Why does that become significant? Because as is consistent with the existing inspection contingency, buyer is prohibited from delivering any or all of buyer's inspection report except the recommendations that are necessary to trigger the additional inspection provision. So set that aside for a moment. We all know that buyer has the right to attach the inspector's recommendation for the additional inspections. Let's move on to this next topic, which is that other than that, buyer has no right to deliver any portion of buyer's inspection report or buyer's entire inspection report unless seller has consented to buyer's delivery of that report. And if buyer or buyer's broker delivers buyer's inspection report or any pages of buyer's inspection report without seller's consent, then the new form says buyer's inspection contingency is deemed waived. There is now a consequence associated with buyer's delivery of the inspection report or any of its pages without seller's consent. The consequence is that buyer's inspection contingency is deemed waived. So how would seller consent to receive buyer's inspection report? There's two ways that seller can consent. The first is embedded on the first page of Form 35. It's paragraph 4B. Seller can consent by marking a box to either receive the entire inspection report or the portions of the inspection report related to the repair request that buyer is making. If seller marks one of those boxes prior to mutual acceptance, and if marking one of those boxes is the only change seller makes in buyer's offer, then it is not deemed a counter offer. Buyer can make that change. Seller can mark one of those boxes without causing seller's response to be a counter offer if that's the only change in the offer that seller makes. There's three changes that a seller can make in any buyer's offer that don't in and of themselves constitute a counteroffer. The first is to correct the spelling on their name. The second is to identify their FERPA status. And then now this is a brand new one. The third one is they can consent to receipt of some portion or all of the buyer's inspection report. If the seller doesn't consent on the face of the Form 35 and then later wants to consent to receipt of some portion of the report, seller can use a new form. It's Form 35C. It is included in your materials. You can take a look at it. It essentially looks exactly like this quoted language from paragraph 4B. Now, here's what I want you to think about as listing brokers. When you hear this presentation of information, and certainly this is what I contemplated until somebody asked in a class and made me think outside the box. When I heard this, when I first became familiar with this new form, and as I presented the information for the first few classes, in my mind, the buyer leaves this paragraph 4B of Form 35 blank, and it's up to seller to mark one of the boxes. Is that to say that buyer can't mark one of those boxes and try to force seller's hand with respect to accepting some or all of the inspection report? Of course, buyer could mark those boxes. So listing brokers, you've got to pay attention to this issue. If your seller doesn't want to receive the inspection report, but buyer has marked the box under paragraph 4B of Form 35, indicating that seller does consent to receipt of the buyer's inspection report, and you don't notice it, and your seller doesn't notice it, and your seller accepts buyer's offer with that box marked, your seller has consented to receive the buyer's inspection report. You've got to pay attention to that issue. So what do you do as the listing broker if buyer has marked that box and seller does not want to consent to receipt of the form? It will be a counter offer for seller to change that. Why? Because the boilerplate language says that it's not a counter offer if seller marks one of the boxes. It doesn't say that it's not a counter offer if seller unmarks one of the boxes. So you would have to pull out probably a Form 36 in order to make clear what you're doing, and you would have to write language on there disavowing, if you will, the consent created by buyer's check mark of the box under 4B. You would have to withdraw any consent implied by buyer marking that box. Or you can counter in any way that makes sense to you that you can prove that seller did not consent to delivery of that inspection report. Okay, there's another minor change to the Form 35, but let's take any questions that are out there before we get there.
Let's see.
Any
So
questions?
yes, so during the initial inspection period, buyer is allowed several appointments at the seller's home to accommodate these other specialists?
There is no limit on the number of times that buyer can bring somebody into seller's home during the initial or the additional inspection period. Buyer has the right to inspect seller's home with all of these various inspections that buyer believes are necessary in order to satisfy buyer with respect to the condition of seller's property. There's not now, and there never has been, a limit on the number.
Okay, with the new changes to 35 inspections, is a buyer wants to get bids to replace, repair a roof, do they still wait for the additional 5 days?
No reason to do so. Get that roofing contractor out there as soon as you can so that you know that you get the bid back in time to make a timely response to the seller regarding the repairs that buyer wants made.
Okay, does 4B constitute a counter on purchase sales agreement?
Nope, no counter. If seller is the one to place a check mark box on 4B, it is not a counter.
Is buyer obligated to give seller the form buyer has paid for their inspection? Can they request payment?
Nope, seller can consent to receive the form. Seller cannot obligate buyer to provide the form. So if buyer does not want to give seller a copy of their inspection report, buyer's not obligated to deliver a copy of buyer's inspection report. Seller can consent to receive it. Seller can't demand that they receive it.
Okay, you couldn't just write on the form, seller does not consent?
You need to make sure that it's clear. However it's drafted, I'm not going to tell you in this class how to draft the provision. I'm just going to say that as the listing broker, you have to make sure that seller's withdrawal of consent or lack of consent is clearly communicated as part of the terms of the agreement. However you think you can best do that, I'm not going to object as long as it's clear.
Is buyer obligated to give seller form? Buyer has paid. Oh, did I?
No.
We're all done. Okay, questions are complete.
Nice. Okay. So the balance of the inspection addendum revisions are really to eliminate paragraphs that you're accustomed to seeing on the Form 35, and that is the disclosure that buyers already conducted a pre-inspection or buyer's waiver of inspection. Those paragraphs are no longer housed on Form 35. They are now included instead on a new form. It's called it's number 35W, and 35W includes the waiver of inspection contingency, the pre-inspection has already been conducted provision, and then a new provision, basically blank lines, giving buyer the opportunity to negotiate repairs or concessions from seller based on buyer's pre-inspection. That's it with respect to 35 and the changes to 35. Escalation addendum. Oh boy. If you've ever taken a forms class from me before, you know that I teach with respect to the escalation addendum that the form is very difficult to use. It can lead to enormous confusion with respect to what the purchase price actually is, and that it's my recommendation that if the parties want to use the Form 35E escalation addendum to negotiate the purchase price, they do that. They use it to negotiate the purchase price, but that they document the purchase price in some other way, either on the face of Form 21 or through a counteroffer addendum. Form 35E has been revised, and the revisions take out some of the ambiguity associated with what the purchase price will be. The form is still difficult to use. The idea behind the escalation addendum is this. Buyer goes to seller and says, seller, I am so in love with your property, I don't even care what the purchase price will be. The purchase price could be anything from this amount to this amount. I don't care. You pick. Now, to have a form that says essentially that, you're going to have some difficulties with the form because that is, frankly, a crazy provision. But we are in a crazy market. And so buyers are doing all kinds of crazy things, including adding an addendum that says, seller, you pick the price. And the way that buyer says that to seller through the escalation addendum is to say, here are the parameters, seller. I'm going to pay X amount over whatever the highest price competing offer is, or whatever competing offer you pick. It doesn't even have to be the highest price. Whatever competing offer you pick, I'm going to pay X amount more than that price. Up to this cap, and my cap is whatever I say my cap is, but as long as my purchase price doesn't exceed this amount, I'll pay anything from my offer price to the cap, whatever it comes out in between. And the only real condition I place on you, seller, is that when you escalate the price, this amount, over the next highest competing offer, it has to fit my definition of competing offer. And my definition of competing offer is identified in the boilerplate language that it has to be a bona fide offer. What's a bona fide offer? A bona fide offer is an offer that the seller could make binding by accepting it. So a seller can accept it and create a binding agreement. That's a bona fide offer. It has to result in cash to seller at closing. It doesn't have to be an all-cash offer. It could be buyer getting financing, but it has to result in cash at closing to seller, so it can't be seller financing. It cannot include a Form 22B home sale contingency, and the closing date has to occur not later than the date specified on the face of buyer's Form 35E, 60 days by default, but there's a blank line on line 19 of the revised escalation addendum, and that blank on line 19 in paragraph 2 allows buyer to dictate that the competing offer's closing date will not be more than whatever the number is filled in here. Why is that important? Because if the buyer is an all-cash offer and they're ready to close in 20 days, they don't want to compete with the buyer who's got to go get financing and needs a 60-day close, right? So the buyer can define the outside closing date of any competing offer. And then the Form 35E provides a mechanism, it's on the second page, it's a calculation table that the seller can use to calculate the purchase price, the new purchase price that the buyer is going to pay. And when the seller delivers the 35E, the escalation addendum, along with the rest of buyer's offer, back to buyer, if there's no changes made in buyer's offer, but the price is escalated, then seller has accepted buyer's offer, not countered buyer's offer, but accepted buyer's offer, and buyer is bound by the terms. And so one of the problems with the existing form is that if the competing offer wasn't really a competing offer, what does that mean if seller has accepted buyer's offer and the price is escalated? Or if seller's calculations are wrong, seller determines the price is X when really the price should be Y, but seller has accepted buyer's offer, what does that mean? And so what the boilerplate language of the existing form says is, seller, if you screw up and the competing offer isn't really a competing offer as that term is defined, then the price doesn't escalate. Buyer's offer price is the purchase price at the closing table. Sorry if that's not the outcome you wanted, seller. And moreover, seller, if you screwed up your calculations and the price is really Y and you said it was X, then at closing the price will be Y. Whether that's an error in seller's favor or buyer's favor is irrelevant. The actual accurate calculation will be the price that's reflected at closing, regardless of what seller might have thought the price was based on listing broker's calculation. That's the weaknesses that are addressed by the modified forms. There is one other modification in the calculation section. When we get to that, there's a new line added for brokers to calculate, for the seller and listing broker to calculate, in addition to credits that the buyer asks for buyer's benefit. Some buyers these days are actually giving credits to the seller to incentivize the seller to accept their offer. So there's a place in the calculation table now to add in the credits to the seller, and we'll get to that in a minute. Okay, so how do we accommodate for the scenario where the competing offer is not really a competing offer? When the buyer receives back seller's signed escalation addendum escalating the price, seller must include a copy of the competing offer. If seller, meaning listing broker, fails to include a copy of the competing offer, when the seller's acceptance goes back over to buyer and the price is escalated, the effect of listing broker's failure to include the competing offer is that the price does not escalate. Seller may think that they're escalating buyer's price by $30,000. Listing broker forgot to attach the competing offer when it went back over to buyer. Price doesn't escalate, but seller does not get that extra $30,000. Listing brokers, you cannot fail to include a copy of the competing offer if seller escalates and accepts buyer's Form 35E offer. So let's assume that listing broker doesn't err. Listing broker sends over the 35E along with the competing offer, and buyer looks at all of that and says, hold the phone, this competing offer is not a competing offer. It does not meet the definition of competing offer set forth in paragraph 2 of Form 35E. In that scenario, buyer, within 3 days of receiving, 3 days by default, you can negotiate to do whatever, but by default, within 3 days of receiving seller's acceptance of the 35E and escalating the price and including a competing offer, buyer has 3 days to say, seller, this is not a competing offer. The price did not escalate. At closing, the purchase price will be my offer price, period, end of story. Upon buyer's delivery of that notice to seller, seller now has 2 days to say, that's not how I saw this. So forget it, buyer, deal is off. I terminate the agreement, or, okay, I see what you're saying. All right, purchase price was your offer price. Those are seller's two choices. Terminate the transaction, close the transaction at buyer's offer price because the competing offer was not a competing offer and it didn't escalate the price. That solves the first ambiguity. Second ambiguity is that seller miscalculated, or at least buyer thinks seller miscalculated the new escalated purchase price. Within 3 days of receiving seller's calculated purchase price, buyer has the opportunity to deliver to seller notice that seller's math was wrong. Seller, you said the purchase price is $350. I did the math myself. The price is only $339. At closing, the price is going to be $339, period. End of story, seller. I deliver that notice back to seller. Seller now has 2 days by default. Negotiate to be whatever number of days you want. Seller has 2 days by default to say, that's not the way I do the math, buyer. I think you're wrong. Or, oh, you're right. I guess my math was wrong, but I don't want to sell it to you at $339. I'm going to sell it to somebody who made an offer at $345. So fine. Deal is terminated. Or seller can agree that the price will be $339. All of these notices between buyer and seller will be delivered, must be delivered. This is one of those rare opportunities in the statewide form when the form that you use is dictated by the forms themselves. To deliver any of these notices, the buyer and seller must deliver the notice on Form 35EN. Okay, are there questions?
No, not for this. Oh, there's one that just came in. Confirming if listing agent accidentally does not provide the offer, causing the escalation along with the acceptance of the escalated offer, then the 3-day timing begins.
If listing broker fails to include the competing offer, the purchase price just doesn't escalate. The boilerplate language is really clear. No notice is required. The purchase price simply does not escalate if the competing offer is not included. Let's do a little practice. I want you to answer these questions in the chat box. The answers that you can give are give notice or say nothing. Now, please know that I understand that you will always talk to the buyer, and there could always be times when the buyer says, I know I have the right to give notice, but in this set of circumstances, I'm not going to. I get it. I know that could happen. That's not what I'm looking for as an answer. I'm looking for an answer that says, based on the facts, you have the right to give notice, or there's no opportunity and you're just going to say nothing at all. Okay? That's what I'm looking for. So you represent a buyer. You're the buyer broker. Buyer's offer is for $400,000 with a $1,000 escalator up to a cap, a maximum purchase price of $450,000. In paragraph 2 of Form 35E, buyer writes 30 on that blank. So take a look at Form 35E and see what I'm talking about when I say the buyer writes 30 in paragraph 2. Okay, here's the questions I want you to answer. What do you do when seller escalates to $435,000 and the competing offer closes in 45 days? Do you give notice or do you say nothing at all? Okay, most of you got this right, not all of you. The answer is that you would give notice. Remember, you only have 3 days from the time that you receive it. Somebody said, don't give notice yet, just wait and see what happens. You can't do that. Buyers only got 3 days to give notice. And this competing offer is not a competing offer, as that term is defined by buyer, because buyer said you had to have a 30-day or less closing. That's what writing 30 in paragraph 2 means. So in this scenario, you would give notice because the competing offer is not a competing offer. All right? What about this scenario? Seller escalates to $420,000. The competing offer expired yesterday. Give notice or say nothing? Okay, most of you are getting this right. You would give notice. Why? Because remember that one of the requirements for the competing offer is that it has to be bona fide. What did I say is a bona fide offer? A bona fide offer is one that the seller can accept and make a binding agreement. If the offer expired yesterday, can the seller accept it and make a binding agreement? And the answer is no, because it expired. All that seller could do is counter on the same terms of buyer's offer, but you got to change the expiration date. Seller can't accept and make binding an expired offer. So giving notice is the right thing to do. What about this scenario? Seller escalates to $443,000. The competing offer includes a Form 22Q, a pending sale contingency. Give notice or say nothing? Okay, kind of mixed answers in this one, but the only answer that's correct is say nothing. Why? Because a Form 22Q is not something that invalidates the competing offer. Remember, the definition of competing offer is bona fide, cash at closing, and no Form 22B. There's no requirement that a competing offer can't include a Form 22Q. So buyer's offer that includes a Form 22Q does meet the definition of competing offer. All right, last question. Seller escalates to $450,000, but no competing offer is provided. Give notice or say nothing? Okay, it seems like you're about half and half on this one. This one is a trick question. Although somebody asked a question about this, and I gave the answer just a couple minutes ago in response to a question that was asked. If the seller fails to include a copy of the competing offer, or the listing broker fails to include a copy of the competing offer, the language on the face of the Form 35E, paragraph 3A, says right on its face, the price doesn't escalate. No reason to give notice. In fact, if you give notice, you're giving the seller the opportunity to terminate the transaction. That's not what buyer wants you as their buyer broker to do. Buyer broker wants you to understand the operation of the form itself. And the operation of the form itself is to say that if the competing offer is not included when the seller escalates the price and accepts the offer, then the price did not escalate. And the purchase price is what the buyer's offer price was. No notice, because the notice gives the seller the opportunity to terminate, and that's definitely not what buyer wants. Okay, let's practice something else in similar vein. We have the exact same buyer, $1,000 escalator, $450,000 cap, and if you read the rest of the buyer's terms, they are asking the seller to contribute $10,000 for replacement of the roof. I got to get that roof replaced, seller, so that I can get my financing, but I have a little bit of extra cash. So seller, to sweeten the deal a little bit, I'm willing to pay $3,000 of your closing costs, okay? That's the first buyer's offer. The competing buyer offers purchase price of $420,000, They also have an escalator that goes up to $435,000. They ask the seller, the competing buyer asks the seller to pay up to $5,000 of the buyer's closing costs. But in order to incentivize the seller, the competing buyer broker's office offers to reduce the selling office compensation from $12,000 to $5,000. Now, I want you to either use this chart, which is in your PowerPoint materials, or pull out your Form 35E, the second page. At the top of the page, you have the worksheet. Go ahead and fill out the worksheet. Calculate what the buyer's purchase price will be based on this competing offer, and put the purchase price, the escalated purchase price, in the chat box. Okay, we probably have enough information to reach a conclusion here. Your prices range. I think I saw the lowest price at $430, and I think I saw the highest price around $448, something like that. And you have almost every price in between, which should be indication enough that, assuming most of you are pretty bright people, and I think that that's probably a pretty safe assumption, we have this wide disparity of purchase price numbers. Of course, we can only have one purchase price. It is math, so there is actually a correct answer, right? It's math. But it's a difficult equation with all kinds of moving parts, which illustrates the reason why I still recommend that even with the clarifications on the form, you agree to a price and identify it on Form 21 or on a counteroffer addendum, and let the parties agree to what the price will be. Here's how I did the actual calculations, if you're interested in that. The highest purchase price as a competing offer is the escalated price of $435. So that's where you start. And I think most of you did that. A lot of times when I teach class, brokers come up with numbers down in the 420s. Those brokers started with the buyer's offer price instead of the buyer's escalated price. I think most of you recognize that you start with a buyer's escalated price. So that's good. Less credits to buyer in competing offer. The competing buyer has asked for $5,000 in closing costs. And so you put $435 minus $5,000, that puts us at $430. The selling office for the competing buyer has agreed to reduce their compensation from $12,000 to $5,000. That's a $7,000 difference. So it says plus credit, so we're going to add that back in to our calculation, giving us a competing offer net purchase price of $437,000. To that amount, you add the buyer's escalator, which is $1,000, takes us to $438, plus credits to this buyer that the buyer is requesting. Buyers ask for $10,000 roof repairs, so that would take us to $448. Less credits, if any, to the seller in this offer. Our buyers offer to pay $3,000 of seller's closing costs, which takes us from $448 minus $3,000 down to a purchase price of $445. Congratulations to those of you who arrived at that number. But the calculation is tough, and the escalation addendum is still a tough form to use. There are some problems in the escalation addendum that I could not solve, period. Like, for example, what if one of the offers includes free rent back to seller? We see that all the time in offers today. That's certainly a credit to a seller. How do you account for that? How do you monetize the value of a rent back to the seller? I don't know. I don't have an answer to that question. One that I think is even more challenging, and I've also seen this. What do you do? You know, when we did the calculation on my made-up example, I made the selling office compensation credit easy. I went from $12,000 to $5,000, but it's not typically flat dollar values. It's typically percentages. the selling office will reduce from X% to Y% of what? Of the purchase price. So now we're trying to determine the purchase price by including a calculation that's based on a percentage of the purchase price that we can't determine unless we know the purchase price. So it's this never-ending circle, and you'll never, ever be able to figure out the purchase price if it's reduced or credited by a percentage reduction in the commission. So the end game here is still the same. Brokers should still be talking, negotiating with one another, and creating win-wins for the buyer and seller based on a negotiated price that is documented either on the Form 21 or on a counteroffer addendum. Are there questions, Liz?
Let's see. Can sellers request buyers not use escalation offers?
Sellers can make that request. Sellers can certainly, and the way I think it would really come up, because no garden variety seller even knows that this form exists, listing broker is going to have that conversation with seller at the time they take the listing. And so listing brokers might say to seller, look, this form is out there. It is a tough form to use. I'm going to recommend that we ask that buyer brokers write offers bringing their highest and best and not including an escalation addendum, but we can't control how buyers present offers. And so seller, even if we make that request, I still have an agency law duty to timely present all written offers, and I will present all written offers to you. In reality, though, seller, it might be nice for you to get an escalation addendum offer, because I'm going to recommend you don't accept it, that you don't document the price on that escalation addendum. But sometimes buyers do crazy things by bringing escalation addendums, and we might get the price even higher by using one. So, seller, I can't really tell you how you get the best price, whether it's to invite escalation addenda or to not invite escalation addenda. I'm just telling you that as your broker who's held to the standard of care of a lawyer in documenting the purchase agreement, I'm going to recommend that whatever price we come to, we document it on a counteroffer addendum or on a Form 21, asking the buyer to rewrite their own offer. However we do it, that's how we're going to do it, seller. Any other questions, Liz?
Why would the seller credit be an increase in the purchase price rather than a credit to the buyer, thereby lowering the price?
Believe me, we went through this formula. I know the formula itself is correct. I honestly cannot take time in this class to explain how the math works, because I have to redo the math in my own mind to make it work. But what you're trying to achieve is a net for net, an apples to apples comparison. So you're trying to make the compensation, the seller proceeds from each offer be exactly reflective of what the other one would. That's why you subtract or add in based on the formula, the way it's written. The formula is correct, even if it doesn't make sense to you on your first read through. Anything else, Liz?
Yes, if the accepted offer and the competing offer are sent in two separate emails due to size of files, does this invalidate the escalation?
If you can't send the seller's acceptance of the purchase agreement and the competing offer in the same email, then listing brokers do whatever you have to do in order to connect the two. If it's to say seller's acceptance of buyer's counteroffer, email 1 of 2, and you do it that way and you link them, fine. My recommendation would be that you send the competing offer in the first one and then the seller's acceptance in the second one. I haven't come up with a reason why that's a bad idea, especially if you do it back to back. Maybe there's some chance that the buyer broker gets the competing offer first and realizes that the buyer's offer the price is going really high, and they all of a sudden withdraw their offer, but I don't really see that happening. And so I think the safest way, if you're going to do that, send the competing offer first and then immediately send the seller's acceptance of the escalation addendum. But however you do it, make it very, 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 very clear that they are both coming back to the buyer simultaneously, but due to size limitations on the email, you're having to send it in two separate emails. But it is part of seller's acceptance and delivery. Anything else?
But the seller can choose the highest price on an escalation, correct, and remove the escalation clause from offer.
Seller can't, as a matter of right, do that. That would be a counteroffer. Seller can counter buyer's offer at any price seller wants to counter buyer's offer. And so if seller wants to counter buyer's offer without using the escalation addendum at all, seller can counter back and increase the price. My recommendation to you as a professional in this industry is that you send back to the buyer's broker a copy of the competing offer so that the buyer has a good feeling about what's happening. Yes, my price really would have been escalated based on the escalation addendum, but the seller is leery of the form itself. I get it. The form is tough. And so the seller provided to me evidence of why the price is going up, but gave me the opportunity to accept it in the form of a counter offer or not. I want to do that. I want to raise the price based on what it would have been anyway and document the price so that we all believe it's a fair price. That's how I think you should do it. But seller has the right to counter at anything they want to counter at. All right. So Liz, we got 3 minutes left. I'm going to go ahead and cover the very last slide. And if there's any other questions, we'll see what they are when we're done with this. Okay?
Okay.
Oh, I'm sorry. It's not even the last slide. This is an important topic. I always forget the slide is out here. Form 65A and 65B, the pre-closing and the post-closing rental agreements. Little tiny change, huge impact. If you've taken a forms class from me before, then you already know that anytime the buyer and seller agree that possession will happen at a time other than closing, then based on the boilerplate language in Form 21, buyer and seller automatically agree that if buyer takes early possession, the parties shall sign a Form 65A. If the seller retains delayed possession, the parties shall sign a Form 65B. And if you put all that together, what it says, Form 21 says that the agreement of Form 21 is that the parties will sign a subsequent agreement regarding the rental of the property. And if you ask any lawyer to complete this sentence, an agreement to agree is, they will say, an unenforceable agreement. An agreement to agree is an unenforceable agreement. Why? Because what happens if buyer and seller don't agree to the terms of 65A or 65B when it's put in front of them at the time of possession? All of a sudden, we don't have agreement on the rental agreement, and the rental agreement was a condition of the purchase and sale agreement. Now, all of a sudden, we don't have a binding agreement for the Form 21. And there has been a problem with 65A and 65B until March 3rd of 2021 because there's language in the 65A and 65B in both cases which says landlord acknowledges receipt in the amount of. And because of that language, it was impossible for a landlord, either buyer or a landlord seller, to sign the 65A or 65B at the time that possession other than closing was determined, because they couldn't sign a form that said that they were in receipt of a rent in the amount of blank because they aren't receiving rent until sometime later. So the revisions to Form 65A and 65B in both cases is to eliminate that language. So now it no longer says that the landlord is in receipt of rent. That's gone. Instead, it talks about that rent that will be paid. The beauty of that is this. Now, when buyer and seller agree that possession will happen at some time other than closing, that's when, broker, you should pull out either 65A or 65B, whichever it is, fill it out, have the buyer and seller agree to the rent amount, to the date, whatever it is, fill in all the blanks on the 65A or 65B, and buyer and seller sign 65A or 65B right then. Now Form 21 is no longer an agreement to agree, they've already agreed. So when they sign Form 21, they've already agreed to the terms of the 65A or the 65B. We no longer have this weakness in the purchase and sale agreement. This is a small change with a huge and significant impact. Make sure you understand how to use 65A and 65B. And then, oh gosh, there are some more slides. How did I get here, Liz? I ran out of time at this time. These are important. We're going to go through these very quickly. Minor forms revisions, the Form 38A, the backup addendum. The seller boilerplate says in today's form that the seller will give notice that the backup buyer has failed within 3 days. The boilerplate is now changed to 2 days. It's not a fill in the blank, it's boilerplate. Referral agreement Form 11 must now be signed by the designated broker or the branch manager of each firm on both ends of the referral form. The commission disbursement form just updated. Contingency property notice form 90K. This is the notice form that accompanies Form 22B. Remember I told you that Form 22B has been revised to make clear that the buyer whose sale fails after their home sale contingency has expired has the right now to as always, but by clearer language, has the right to waive their home sale contingency and proceed to closing of the transaction. That option is now captured in Form 90K as an option available to the buyer. Brand new forms. There's a brand new survey contingency addendum. You've never seen it before, but it's in your materials for this class today, Form 22TS. Really no moving parts in this. The one thing I want to make sure that you're aware of is that the buyer's contingency is 14 days by default. If you have tried to hire a surveyor, get them to the site, get the work done, and get their survey product back, it very likely will take far more than 14 days. So if your buyer really wants a meaningful survey contingency, make sure you've communicated with the buyer's surveyor in advance and you know how many days to put into this contingency. Termination of buyer representation agreement. Buyer agency agreements Form 41 and Form A and Form 41B are both terminable by right by either party. If the buyer terminates the agency agreement after the broker has already performed, the buyer still has the obligation to pay compensation, but both buyer and broker have the right to terminate the buyer representation agreement. A new Form 53 is what you would use to do that. Similarly, a new Form 54 is what a broker or seller would use to terminate the seller agency agreement created by Form 47. There is a blank notice agreement, blank addendum Form 68N. It's like Form 34, but it's intended to accompany a lease transaction. So property managers, you've now got a blank addendum to go with your lease documents. It's Form 68N. A new notice form, you'll know, hopefully you already know that all the termination provisions are housed in the Form 90 series. Form 90EF is a notice of termination pursuant to the evidence of funds addendum, and a brand new Form 90LR is a termination provision associated with the lease review contingency addendum. Finally, I just want to bring to your attention that while it seems like a garden variety practice in King County, Snohomish County, and parts of Pierce County to make money available to the seller, to make buyers money available to the seller prior to closing, this is an anomaly in our industry. This is not business as usual. This is extraordinary and it is dangerous. And it is only a matter of time before some buyer broker who's held to the standard of care of a lawyer when you prepare a purchase and sale agreement is sued because a buyer has given money to the seller prior to closing. Seller can't close the transaction and seller doesn't give back the buyer's money. The other day I saw an agreement drafted. Buyer gave $40,000 to seller the day after mutual acceptance. And I want you to tell me what's going to happen to that buyer's $40,000 if on the way to closing, seller is in a car accident, find themselves unconscious in a hospital bed, unable to sign a warranty deed, and the transaction can't close. And the seller's family says, I don't know what $40,000 you're talking about. Seller's unconscious. We don't know what's going to happen to him. You're not getting your $40,000 back. What are you going to do, buyer broker? How is the buyer going to get their money back? And the answer is, I don't know. And what I do know is if a lawsuit is filed, you're not going to be able to fall back on business as usual historically in our industry because this is an anomaly historically. You're also not going to be able to point to other geographical regions around the country and say, you see, everybody was doing this. Because based on what I can tell, having had a conversation with all the other industry lawyers, including industry lawyers who represent brokers in Washington State and in other parts of the country, including Washington, Oregon, and California, they're telling us we're not doing this in California. If the crazy practice is going to happen anywhere, it's going to happen in California. Even crazy California is not making money non-refundable and released to seller prior to closing. So brokers, I know you got franchise forms that allow you to do this. If you asked your franchise lawyer, they would say, we wish that buyers weren't giving money to sellers prior to closing. But they would also say, if your buyer insists upon that as part of their offer terms, then please use the form that we provided for you to do that. Many franchises are providing these forms right now because they know that brokers are preparing the language themselves if the franchise doesn't provide the form. I think the franchise forms are better than nothing at all, but please know, even if you're relying on a franchise boilerplate form for this practice, it is a very dangerous practice. Okay. I apologize for running over on the length of time. Hopefully answering some questions made it worth running over the end of the class. But Liz, I'll turn it over to you to wrap up.